Welcome to Dementia-Friendly Prince George's County, Maryland Northern Sector Webinar Series for Caregivers. Today's topic is When and Why Should I File for Medicaid? This video is sponsored by Prince George's County Government and the Department of Family Services.
Hello, everybody. Thank you for everybody who's able to tune in tonight, and hopefully you get some good information out of this. Specifically, I'll be talking about long-term care this evening, which first thing to get rid of a little bit of confusion, Medicaid is a shortened term for medical assistance. So particularly if you do ever move into applying for Medicaid, the term that the government will use by and large is medical assistance. So don't ever let that Medicaid versus medical assistance confuse you. Those are one and the same. They are synonyms. And specifically tonight, we'll be focusing on long-term care Medicaid. So briefly, there is another kind of Medicaid called community Medicaid, which is more of a health insurance plan for example, it's become much more frequent in recent years through the Affordable Care Act for people with low income or low assets who are in need of specific health insurance, but they are still very much in the community. We'll be focusing on tonight is more of the quote unquote traditional Medicaid, which is for long-term care for people who need to be in what the government calls a skilled nursing facility. So of course the question is, whenever anybody talks about long-term care, who pays for it? That's of course question number one. And a lot of times is who cares for it, and there's lots of aspects that you'll see there that are encompassed in long-term care. So of course there's some of the things that you'll see below in larger letters are eating, bathing. Those are examples of what's called activities of daily living, and you'll see that discussed as we go on here. So paying for long-term care. So some examples, of course, one possibility for those of us who are fortunate enough to pay for long-term care, one way is private paying, which means using your personal funds, whether it be specifically yours individually or somebody else, family or friends, somebody else who might be able to pay. Up above that there, you'll see long-term care insurance. Long-term care insurance is, of course, an insurance policy that can pay for whatever health care you might need. One way the long-term care insurance, frankly, is better than Medicaid is that by and large, long-term care insurance pays for care that is regardless of where you are, whether it be you stay in your home, whether you're in an assisted living facility, or whether you're in a skilled nursing facility, which is, by the way, the highest level of care. People often just generally use the term, I need to go to a nursing home. And unfortunately, that's not specific enough, because what people call a nursing home might be an assisted living facility, might be a might be a skilled nursing facility, but by and large, Medicaid only pays for that highest level of care, that skilled nursing facility. Whereas long-term care insurance, if you're fortunate enough to be able to afford it and have good enough health when you are applying for long-term care insurance, it will generally cover more than Medicaid will. And then down there at the bottom is what we've talked about around so far, and what we'll be focusing on tonight is, of course, Medicaid itself paying for your skilled nursing facility care. Now, there are certain waiver programs. Every state has a certain number of slots for people to get in-home care or assisted living care, but by and large, I'm just going to say don't really focus on those, because there is such a long waiting list for those. There's years-long waiting list that we're going to be focusing on the more common way of qualifying for Medicaid, long-term care Medicaid. So A misconception about long-term care insurance, now that you see it at the top, is Medicare. We're going to spend just briefly time talking about Medicare. One thing I truly do not like about these terms is that Medicare and Medicaid sound so similar, but they are absolutely not the same, as we're going to go over right now. Medicare is what most people have for their primary health insurance when they reach 62 and older. Then of course there are some when you who get it younger if you are on disability, but Medicare is not a long-term care policy. I'm sorry, I said 62, excuse me, 65 and older, or if you're disabled for 2 years. And that's if you are on SSDI, Social Security Disability Income. Now, specifically for long-term care, Medicare will pay for up to the first 100 days that you are in a skilled nursing facility, but only if you are admitted previously to the hospital for at least 3 consecutive midnights, and then you enter the nursing home, which again, that's a general term. What we're really talking about is what the government will call a skilled nursing facility, SNF. If you are entered into a skilled nursing facility within 30 days of discharge from that hospital. So Medicare, once you are entered that skilled nursing facility, Medicare will pay for the first 20 days in full. And that can feel like a relief at first, but often even the skilled nursing facility doesn't really explain to the the patient or the family until say day 18 or 19, where they say, okay, where's the money going to come from now when the 20 days is up? So a lot of people don't find out until 2 days before the 20 days end that they're going to start to be on the hook for some money. So Medicare, after the first 20 days, will pay a reduced rate for the next 80 days. And as of 2021, the year we're in now, of course, is the patient will pay a copay of $185.50 for each of those 80 days. And then after those 80 days are over, the 20 plus the 80, Medicare pays for none of the long-term care. And that's where the true long-term problem comes in, where people say, how do we pay for this? There you go there. So after day 100, Medicare does not pay for the long-term care. And technically the patient is supposed to be given 24-hour notice when Medicare will terminate, and that does happen. Medicare is quite particular about when they will not be paying any longer. So qualifying for Medicaid, there are different levels of benefits. The first one, frankly, we're not going to be spending an awful lot of time on. That's the technical eligibility. You need to be 65 years old or older, or blind or disabled, a U.S. citizen or a resident legal alien, and a Maryland resident. And that, of course, we're in the DMV area. There's a lot of leeway there. You don't necessarily need to be a Maryland resident for a year or 5 years before you go on Maryland Medicaid. Really, you can be 1 day. So there's not a huge, the problems normally do not come in on the technical eligibility side. Where the issues for qualifying for Medicaid, long-term care Medicaid, really start to come in is when you get to the medical eligibility. So to qualify for long-term care Medicaid, and this is where you start analyzing your situation that you're experiencing with your loved one, is does your loved one need hands-on assistance with at least 2 activities of daily living? That's ADL. You'll see that repeated throughout here. ADL is then the abbreviation for activities of daily living. And those examples there are bathing, dressing, transferring from sitting to standing position, walking, eating, and toileting, and skilled nursing care facility level of care. Or another way you can get to it is if you need supervision of at least 2 ADLs with a cognitive deficit, the score of 9 on the BIMS scale, and needing assistance with the 3 at least instrumental activities of daily living. And that's the telephone use, money management, housekeeping, and medication management. That one is frankly much more common for somebody who is still quite physically capable, but they're having a lot of, again, cognitive difficulties, which is an example is the various kinds of dementia. So that's how often people who are on dementia qualify for it, whereas the top level care is much more about much more extensive mental and physical difficulties, or sometimes just plain physical difficulties is what that first one, the needing hands-on assistance, that tends to be somebody who might still be mentally 100% capable, but they're physically unable to care for themselves. And then down at the bottom is probably the least common of the 3 ways of medical eligibility, but it's whether you need supervision of at least 2 ADLs combined with the supervision for at least 2 behavioral problems. And those are listed there, the hallucinations, aggressive behavior, and so on. So that's probably the least common that we see of qualifying for medical, meeting the medical eligibility requirement. So now, attorneys are quite limited in how attorneys can help with the medical eligibility side. By and large, that depends on whether doctors, trained medical providers determine that you need this eligibility. Now, sometimes there can be hearings where an administrative law judge might decide whether you meet the medical eligibility. If some doctors say that you do not meet the medical eligibility requirement, but you say that you do, or you say that your loved one does. But by and large, the medical eligibility determination is left up to the doctors. If the doctors say that your loved one qualifies, then your loved one will qualify. Where attorneys really do come in can be very helpful is the next way of the next criteria for qualifying, which is the financial eligibility. So there are income requirements, and what I'm going to informally call assets, but in medical assistance government jargon, it is called resources. But income is about basically what monthly income do you have coming in? Do you have your Social Security retirement income? Do you have a pension because you are a state worker or a federal government worker, county worker, or are you one of the people who's still fortunate enough to have a pension from your from a private company? Of course, fewer and fewer people now retire with pensions from private companies. But if your loved one still is fortunate enough to have that kind of monthly income, or do they, of course, they have a rental property where there's monthly income coming in from that? That gets into another area that we'll talk about perhaps. And then there's again, what's listed as assets there really for ease of reference, but what again the government actually calls resources. So we'll get into the differences in a few minutes about whether the person who is applying for Medicaid, the ill person, or what's called the institutionalized spouse in Medicaid language or jargon, is whether they're single or whether they're married at that time. Essentially, what you need to bear in mind to focus on is if the disabled person can only has to have less than $2,500 as of the first day of the month that the Medicaid application is filed. I will say we're not going to get into a lot of detail tonight about the specifics of exactly everything with a Medicaid application, because we would be here for hours just talking about that. So this is more of a high level discussion of the basics, but definitely need to know that you need to have less than the $2,500 as of the first month in which the Medicaid application is filed. So the assets again of a single person is $2,500. Now, if you are married, and assuming the married person does not also need skilled nursing care, then these figures here really apply, and that the community spouse, which again is the medical assistance term for the spouse who was still healthy enough to not be in a skilled nursing facility, that community spouse is allowed to keep what's a minimum of $26,076 as of January of 2021 in assets. That's in addition to the $2,500 of the single person. I mean, excuse me, of their disabled spouse who was in the skilled nursing facility. Excuse me. And combined a maximum of $130,380. So that is what's called the CSRA. That's the abbreviation for that. And those assets are the total assets, again, as of the first of the month in which the spouse enters the nursing home for the 30 continuous days. And so what that is sometimes the as part of it is how assets are titled to a certain degree. So it's the point is, can some money come from the disabled spouse to the married spouse to get them into this to the minimum of 26,000 or the maximum of 130,000, so that the married person can keep assets to help them keep living in the community. Income there on the left, now you see coming in. So the married person is also entitled to a what's called a minimum monthly maintenance needs allowance. That's a lot of M's and then an N and an A. So that's $2,177.50. That was just updated very recently as of July of 2021, the beginning of this month. And then a maximum of $3,259.50. So what that is, an easy example of this, like you see down there below, is let's say that the ill spouse, the one who is the quote unquote institutionalized spouse in the skilled nursing facility, has $6,000 a month in income between their pension and Social Security retirement. But the healthy spouse is in the community and has maybe $1,000 a month in income of their own. That MMM&A is saying that a portion of the ill spouse who has $6,000 of monthly income in that scenario, a portion of that is allowed to be moved to the healthy spouse, so that the healthy spouse can again keep on living in the community. So instead of all of the that $6,000 having to go to the nursing home. This one thing that has not really been put on here is the income, whatever is charged or assessed as counting towards the skilled nursing facility spouse. That has to go to the nursing facility, and then with a very small monthly allowance deducted of about $80. But otherwise, the ill spouses, all their income goes to the nursing home. And what Medicaid does is they pay the difference so if the skilled nursing facility spouse has $6,000 a month in income and the healthy spouse has $1,000 a month in income, then approximately in that scenario, $1,177.50 would be taken from each month from the skilled nursing facility and transferred to the healthy spouse to get the healthy spouse up to that minimum of $2,177.50, so that the skilled nursing facility spouse then has closer to about $4,200 a month. That basically that $4,200 a month goes to the nursing home or skilled nursing facility each month. And then the Medicaid program pays for the rest of the Medicaid bill for that month. So again, more things to know about qualifying for benefits here. There is the home exemption. So home exemption, that again, it differs based on whether you are single or whether you are married. To start with the more simple scenarios, if you are single and you are applying for a long-term care Medicaid, the home that you own, where you actually live, that is exempted from Medicaid as long as you are committed to at least trying to come back home, as opposed to throwing in the towel, so to speak, and saying you never, ever, ever want to try to go back home again. But if you at least if you at least intend to try to go back home at some point, your home can be exempt for qualifying for Medicaid. But the big thing to bear in mind is that the state of Maryland would have the right to place a lien on your home for whatever the government pays for you on the Medicaid program, and that lien would become effective or become due after you pass away, after the ill person on Medicaid actually passes away. So that's again what I was talking about there, that you can exempt the home, but only if you intend to return home, which everybody who goes into a nursing home by and large at least intends to return home. So it will be included in the applicant, the ill person on Medicaid, their own estate when they pass away, and the state of Maryland's Medicaid program has the opportunity at least to file a claim against the estate. Frankly, Medicaid office does not always file a claim, but you just will not know whether they file a claim until that time actually comes, after your loved one passes away. Now, so if married, so the home is exempt and there's no right of recovery against the community or surviving spouse. But absolutely the very difficult scenario is, what if the community spouse passes away before the ill spouse who is in the skilled nursing facility? So that is a very difficult scenario. There is a portion of time when you are married, and one spouse goes into a skilled nursing facility, that certain retitling of deeds is allowed to occur. But at the same time, if the community spouse passes away, first, there is a law now where a third of what's in the community spouse's estate, at least a third, has to be used for at least put into a trust for the ill spouses or the Medicaid spouse's benefit for the rest of the Medicaid spouse's life, because that it does happen that where the community spouse who is healthy and still in the home just happens to pass away before the ill spouse who was in the skilled nursing facility, the Medicaid spouse. And that 1/3 that I was talking about, that's what's known in Maryland as the spousal statutory share. So proper planning with an attorney can make sure that that 1/3 goes into a trust, as opposed to going directly to the Medicaid spouse, which would mean that 1/3 just really immediately goes back to reimburse Medicaid, as opposed to being in a trust where there's much more control over it. So single or married, some exemptions are if you have a minor. I understand that's not as common for a person who is in a skilled nursing facility to have a minor child, but it does happen. But if the disabled person has a minor child, or they have a disabled child residing in the home, then the home will be exempt from a Medicaid lien or a Medicaid claim. Child caregiver exception, sometimes this works out as if one of the disabled person's children resides in the home for at least 2 years prior to the parent being admitted to the skilled nursing facility, and that patient's child provided care that allowed the parent to remain in the home for those 2 years or more, then the house can be transferred to the child without penalty, meaning without having to deal with a Medicaid claim. And if a sibling is joint on the title and resides in the home for 1 year prior to admission, the home may be transferred to the sibling without penalty. So that's an overview of the home exemptions. So some other exemptions, by and large, automobiles are not counted when qualifying for Medicaid. Now, we have had the question from time to time that what if the disabled person is Jay Leno and has a garage filled with 10 or 12 cars. Quite frankly, we've never had anybody with that many cars before, but we've seen where 2 or 3 cars are exempted before. And by and large, that all of those were not cars of extraordinary value. So we've never had Medicaid try to challenge the exemption, like say, hey, this person owns a Maserati. We Medicaid want that Maserati sold to be used to pay for care. Personal belongings, really, again, I cannot think of a time right off the top of my head where Medicaid has ever pushed about personal belongings, which is just your personal effects that are in your home, your couch, your chairs, your bed, your so on. Home improvements. That's one of the things, of course, like if you put a back deck on your home, which we can talk about a little bit later. That's one thing. Some people who pursue spend downs to qualifying for Medicaid, where you've got too much money to qualify. There's one of the things you're allowed to spend money on is improvements on your home. So again, if you're really needed to put a new roof on your home, you're allowed to put a new roof on your home as a way to use some of your money to get down to your $2,500 limit. And that is allowed in what is called a spend down scenario. Irrevocable prepaid funerals for the applicant and the applicant's spouse. That's pretty much self-explanatory, but again, you need to make sure that you're getting a proper Medicaid qualifying irrevocable prepaid funeral arrangement there. Life insurance can be very, very tricky. Term life insurance does not count at all for qualifying for Medicaid. You could have a $10 million term life insurance policy, and that's exempt for qualifying for Medicaid. Because the whole point of term life insurance policy is it all depends whether you pass away when that term is still going on. So term life insurance policies have zero value unless you actually pass away during that term, or the disabled person passes away during that term. Now, whole life policies, or the increasingly common hybrid policies that have some sort of cash value, or it says here face value, which is a lesser common term, but specifically the question is whether your life insurance totals up to more or less than equal to $1,500 in face value. If it has more than that, then that will disqualify you from long-term care Medicaid. So exemptions that we touched on before is assets can be used to increase the community spouse's income to the MMMNA. Health insurance, of course, is not counted towards you. I mean, Medicaid loves when you have other insurance that can help cover things that Medicaid does not. So getting down to the heart of, so why is it important to plan ahead for Medicaid planning, medical assistance planning? Is one big thing to take away about medical assistance planning, Medicaid planning, is there is a look back period of 5 years. Because of course the automatic thought that some people might have when they want to apply for Medicaid is, oh, if I get ill tomorrow and if I have a stroke tonight and I have to go to a nursing home tomorrow, then I'll just immediately empty out my bank account and give it all to my cousin. And then I won't have any more than $2,500. That will not work at all. Just plain giving your money away just will not work. Or transferring your home away during the look back period will not work either. There is currently a 5-year look back period that whenever you apply for Medicaid, the medical assistance program in our area, it's called the Long-Term Care Bureau. They look back, they're entitled to review all of your records to see did you give anything away for less than fair market value in that 5-year period before you're applying. And so that begins on the date as of when you are a resident of the nursing home and have applied for benefits. That's probably number 2 to remember, is you really do not actually apply for Medicaid. You don't actually file your application until, of course, you are actually in the skilled nursing facility. And that's, of course, it's something important to remember. So transfers, compensated transfers, that's a spend income and assets to receive full value in return. So for example, It's perfectly fine if 2 years before you apply for Medicaid, you sold some piece of real estate. It was worth $200,000 and you sold it for $200,000. That is perfectly fine because now you have $200,000. You have the market value of your real estate. But on the other hand, if that real estate was worth $200,000, but you sold it for $100,000 to a cousin or whatever, a niece, a nephew, a daughter, that's bad. That's what's called an uncompensated transfer because you sold something for less than what it was worth. Because you did not get full value for what you sold in return. Very common thing that's the underlying part there is a lot of people say, oh, I can give away whatever I want because the government allows me to give away $15,000 per person per year to anybody you want. That does not work at all for Medicaid. That is a rule for gift taxes that the IRS assesses, where if you give away no more than $15,000 per person per year to anybody that you want, that's okay. You don't have to tell the IRS about it, but that's terrible for Medicaid. You cannot give away gifts like that and expect to qualify for Medicaid. So unfortunately, basically when you're doing these gifts, you have to decide, are you trying to follow gift tax law or are you trying to follow Medicaid law? You cannot serve both of those goals at the same time. So the penalty period. So of course, if you are ineligible, let's go back to that scenario. If you had a $200,000 piece of real estate and you sold it for $100,000 to your daughter, or your niece, or somebody, Medicaid would say that that's a $100,000 uncompensated transfer. So again, because you sold it for it was worth $200,000, but you only sold it for $100,000, so you got $100,000 less than it was worth. The government would say the Medicaid program is that that's a $100,000 uncompensated transfer for which you will be penalized, and it is not a dollar penalty for you don't pay a fine. That's not how it works. Instead, a penalty period is assessed, for which the Medicaid will say you otherwise qualify for Medicaid benefits, except you are ineligible just because of that uncompensated transfer. So in that $100,000 scenario, as of July of 2021, that $100,000 would be divided into 10,000 or 10,130 would be divided into that $100,000. And as I double check my math right here while we're on this call, that's about 9.87 months. So the government would say that you will not qualify for 9.87 months, dividing 10,130 into 100,000. So you have to figure out some other way to pay for your long-term care for that 9.87 months. And after that 9.87 months, then Medicaid will start helping with the payment of your long-term care. There is no limit on the number of months the applicant could be ineligible. So, I mean, hypothetically, if you had $1 million and you gave away all $1 million, and then the next day tried to apply for Medicaid, you would be heavily penalized because you'd have $10,130 divided into $1 million worth of gifts. Maryland, however, now let's get to some good news. Medicaid, however, does not impose a penalty if whoever received the gift gives back the gift. Maryland, in that regard, is one of the much more lenient states that if the uncompensated transfer or quote-unquote gift can be undone, then Medicaid will just say, okay, we're going to act like that never happened because we're all back to where we were before the uncompensated gift happened. So again, if you write a $50,000 check to your daughter and your daughter sticks it in her bank account and you apply for Medicaid and to the point that your daughter has not spent the $50,000 and your daughter can give you back the $50,000, then everything's okay as far as Medicaid goes. You've got your $50,000 back, so it's like that gift never actually happened. And it's just, what are you going to do with that $50,000 now that you got it back? And the penalty period does not start down there at the bottom until the first day of the month in which the applicant has applied for Medicaid and is otherwise eligible, like I touched on before, where the only thing that is keeping you ineligible is just the gifts themselves. So asset preservation, and this is another example where attorneys can come into be helpful. Asset preservation, again, by and large, good Medicaid planning is done at least 5 years in advance. Not all Medicaid planning has to be done 5 years in advance, but sometimes the best can. Something that our firm does quite a bit of is that first one there, that life estate without powers deed. What to remember there is if you are committed to never selling your home the rest of your life, you say, I want this home all the way until I die. Even if I die decades from now, I never want this home sold in my lifetime. Then a life estate without powers deed might be a solution for you. Because you can do what that is you reserve for yourself a life estate to live in your home the rest of your life. And then you are naming in that deed who you want to be the beneficiary, or maybe more than one beneficiary on that deed for that house. Literally, the second that you pass away, that's when it takes effect. Then when they become the new owners. But because it's without powers, you are giving up the right to change that deed on your own the rest of your life. So that's why you do a life estate without powers deed if you are truly committed to never selling your home the rest of your life. But the benefit of giving up the ability to change that deed on your own is if at least 5 years pass from when you do that deed, then that house can no longer be subject to a Medicaid lien when you pass away, or be subject to being having to reimburse Medicaid. Irrevocable pure grantor trusts. That is basically a more broad version of those deeds. Some people will have, say, $100,000 in a brokerage account that they do not want to use on themselves the rest of their life, at least that $100,000 principal, but maybe they want the monthly income that keeps the dividends that keep coming in on their $100,000 brokerage account. If you put it into an irrevocable pure grantor trust, and if at least 5 years pass again, although you are still not being able to directly take out that $100,000 principal, you can still be entitled to the monthly income. So really the intent is that whatever you put in that irrevocable trust, you're at least not going to touch that principal the rest of your life. That's the intent, that you're letting it pass on to whatever the next generation or your loved ones that you name in that trust to inherit that when you pass away. Long-term care insurance policies, of course, that's a fantastic option for people who can afford it, number one, and who can qualify for it medically. Have seen a financial advisor say that the ideal time to at least apply for long-term care insurance is the day you turn 60. There's financial advisor. He says that before you turn 60, it's a waste of money to have long-term care insurance, but the day you turn 60, it can be a good investment. So that's at least what a financial advisor we have heard has said. But bottom line is you will not know how much long-term care insurance will cost for you unless you actually apply. Medicaid compliant spousal annuity, that's a very specific thing that's done in what we call emergency Medicaid planning. It's for people who have not done 5 years of advanced Medicaid planning, but they're trying to turn some of their assets into income that will go to the spouse, to the healthy spouse. So the healthy spouse can keep more than the $130,000 that we talked about before. So that is absolutely something that is very delicate, and you absolutely need an attorney for that, just like you should have for really all of these preservation strategies, except possibly long-term care insurance. VA benefits, our firm directly does not do aid and attendance, but that is for somebody who generally who was a veteran during wartime, or if you're sometimes the spouse of the person who was in wartime. We do know law firms who do aid and attendance. That requires very specific admission before to practice before the Department of Veteran Affairs. Then, of course, there's maximizing your Social Security. You know, when is the right time to apply for Medicaid, and when is it too early to apply for Medicaid? I mean, excuse me, when is it too early to apply for Social Security, and when is it the right time to apply for your Social Security retirement?